Hello, this is Jeff Jung, immigration attorney, and I'd like to speak to you a little bit today about the unlawful presence waiver. Unlawful presence waivers are necessary for people who have been in the United States without authorization. If they've been here longer than 6 months, they face a bar of 3 years when they leave the United States, in which they cannot return. And if they've been here more than 1 year, then they have a bar of 10 years. This is a big problem for people who otherwise qualify to obtain permanent residence through their family members, because many people have to return to their country of origin to finish the process, and once they leave, they face this bar. So the good thing is that there is a waiver or a pardon for that illegal presence. And I'd like to talk a little bit about the requirements for that waiver. The first is that the applicant needs to be here in the country in the moment that they apply. As well, their illegal presence needs to be the only ground of inadmissibility, or in other words, their only immigration problem for their case. If they have other problems, such as related to crimes they've committed, or multiple immigration violations, or fraud, then they're not going to be granted this waiver. The waiver is only for people whose only problem is their unlawful presence. They also need to be the beneficiary of a family petition that's been approved. So the immigration process has to have been started for them. They must have a petition approved, and they must have paid up their fees for the immigration process to apply for this waiver. Finally, the most important and difficult ground for getting this waiver is that the applicant has to be the child, son or daughter, or the spouse of an American citizen who will suffer extreme hardship if the waiver isn't granted. Notice that someone who's merely the parent of an American citizen won't qualify for this waiver. One must be the spouse, son, or daughter of an American citizen. And that American citizen must be shown to suffer in either of two cases. If the applicant is forced to leave the country, leaving the relative behind, or if the relative accompanies the applicant to the country of origin. Both need to be they both need to present extreme hardship. What kind of hardship? There are various ways, and each person has their own hardship. We can be talking about problems of health, problems of money, problems of finding work, problems of maintaining one's children, or even problems of maintaining one's other U.S. relatives to whom one has obligations here in the United States. But the problems, the hardships need to all fall on the American relative. The hardships to the applicant don't count. So as you can see, there are various ways of winning this waiver, and there are various challenges presented. And for this reason, it's very important to consult with an experienced and licensed immigration attorney in applying for such a waiver.